Yes. The respondent's case.
May it please the Court. This is a case concerning the reasonableness of temporary emergency accommodation offered in the wake of an eviction. The central issue in this case revolves around whether the applicants can legitimately expect to exercise the same rights and entitlements which would accrue to a person living in their own home at the shelter, and whether they are entitled to claim permanent housing immediately. I'll be dealing specifically with the distinction between permanent housing and temporary emergency accommodation and the reasonableness of the family separation rule. The case made out by the applicants is based upon the proposition that the shelter constitutes their home, and that the accommodation afforded to them pursuant to the High Court order is that of an alternative or substitute home and not that of temporary accommodation. In equating the shelter with a home, the applicants further contend that they are entitled to exercise all the rights and amenities that a person is allowed to exercise in their own home. The question whether this assumption is sustainable lies at the very heart in this dispute, and will assist the Court in determining whether the applicants can legitimately expect to exercise the rights they seek to enforce that ultimately can only be exercised in one's home. We acknowledge that the applicants have a right to a home and everything that comes with a home, but Ikaya is not a home. The applicants were at all times aware that their stay at Ikaya was limited to a maximum period of 12 months that could be extended on a month-to-month basis as recommended by a social worker. The mere fact of residence at Ikaya and the fact that the applicants temporarily have no other accommodation does not entitle them to regard the shelter as their home. I say Ikaya is not a home because there is an inherent distinction between permanent housing and temporary emergency accommodation. It is our submission that the Supreme Court Appeal judgment is correct.
Why?
Because it looked at the circumstances in which these rules were applied and the fact that the accommodation was provided in terms of an emergency. For all these reasons, it is our submission that the family separation rule is reasonable in the circumstances in which it is applied. I have no further submissions. My co-counsel will now continue.
Before you sit down, do we know from the facts how many men are accommodated in the shelter? How many women are accommodated? How many children are accommodated? How many of them are families? How many of them are single?
We only know of the 5 applicants.
So we don't know the other component.
We don't know the others.
Well, we do know that the shelter is full.
Yes, we do know the shelter is full.
May it please the Court, I will be